It doesn't make sense. He's not freaking John Wick. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we just got a whole bunch more documents. Okay, I have decided to not go away from the schedule that I've already figured out in my head that got me out of my mental brain fog. I'm not changing the plan. So I say this in a video that's going to post after this, so I'm just going to say it now and just be prepared to hear it later is really all I can really say. I had finally figured out why I was in such a funk after seeing that huge drop of documents from the state the last time, and it's because I really was just like, not again in my brain because of all of the information that we had just gotten, not even like what, a few weeks before? About a month before from the defense. So my brain was still like in PTSD trauma mode from all of that. And I feel like as I've started doing the like clipping of that old video of all the documents together along with the state's response has helped me sort of like alleviate some of that. And then we got the huge drop of the defense's responses to the state's responses of their original documents earlier today. And I still have so many from the states to still go over with you guys. And we go through every document in this case here. So they have to be done. I don't have a choice. So what I'm going to do in this video, out of this huge section of documents, I'm going to show you the list. And then in this video, we're going to go through the first 3 defense responses to the state's responses to the defense's motions to strike the first 3 aggravators that we went through already with the defense and the states in the one video. Now, the last one that I posted was for the motion to strike the HAC aggravator, or the heinous, atrocious, and cruel aggravator. The one that I was about to finalize and post tonight, it is Friday, October the 25th. That one was for the multiple victim aggravator argument. So that one got put on hold, and now this one's going to come out, and then we'll get back on track from that point. But because we already have the responses for these other 3, I just wanted to put those together in one video because honestly they're not very long. So let's go ahead and get to it. Okay, so this right here is like all of the first ones from the defense that we went over in a 4-hour long video where I put them all together. Then we started going through these ones right here, which were the state's responses. We've gone through the trifurcation. We've gone through them wanting to get rid of the felony murder. We've gone through them with the future dangerousness. We've gone through them with the HAC aggravator. And the one that I was recording, like I mentioned, would be this multiple victims aggravator. So what we're going to do is I'm going to show you this heap of mess right here. This heap of mess right here. We're going to go ahead and open the future dangerousness aggravator and see what this one has to say. Reply to state's objection to defendant's motion to strike future dangerousness aggravator. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby submits the following reply to the state's objection to his motion to strike future dangerousness aggravator. First, Mr. Kohberger would note that it appears the parties agree to call this the future dangerousness aggravator instead of the propensity aggravator. Yeah, we heard propensity in the documents themselves, but they were definitely calling it something else. The first argument Mr. Kohberger made was that Idaho's future dangerousness aggravator fails to narrow the class of individuals facing the death penalty. The state does not attempt to grapple with the myriad problems exposed by Mr. Kohberger's argument that Creech provides a meaningless gloss that merely describes murderers as opposed to those who commit manslaughter. Instead, it oddly enough simply quotes that passage from Creech that undeniably describes manslaughter. And for those of you who don't know who that was Idaho's failed execution a few months ago, and they've got like a date now. They're going to try to execute him again, actually on the anniversary of the Idaho killings on November the 13th. That's the Word on the street so far. Here, it cannot be asserted that the propensity circumstance could conceivably be applied to every murderer coming before a court in this state. We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage, such as during an emotional family or lover's quarrel, commits the offense of murder. We would doubt that most of those convicted of murder would again commit murder, and rather we construe the propensity language to specify that person who is a willing, predisposed killer, a killer who tends towards destroying the life of another, one who kills with less than the normal amount of provocation. We would hold that propensity assumes a proclivity, a susceptibility, and even an affinity towards committing the act of murder. Basically, someone who does something in a lover's quarrel isn't technically somebody who is going to go out and do something to somebody else, even though we've kind of seen that be the case before. I can think of a few stories at the top of my head. State versus Creech from 1983. What the Idaho Supreme Court of 1983 did not grasp is that it was describing first-degree murder as opposed to voluntary manslaughter. Well, that's probably because also it's been a long time, and that's before I was born, and I'm 36. So yeah, that's hella long. So I'm sure a lot of laws and stuff and definitions of laws and stuff has changed. So maybe that's the argument here. The state repeats this mistake rather than grappling with it. Understandably, because to do otherwise would be to admit that Idaho's scheme fails utterly to define those who should be death eligible. I'm sorry, but whoever did this is death eligible. Okay, regardless. The state's real argument is that this court cannot overrule the mistake of the Idaho Supreme Court. They've said that quite a bit. Actually, the state said that a lot in their responses to what the defense was wanting to have happen. This court cannot, but it can refuse to perpetuate them. Okay. But that's probably not going to happen because Judge Hippler seems like he's going to play everything by the book as much as possible. So that's probably not going to happen. Next, Mr. Kohberger argues that this aggravator provides the jury with no guidance. The state now makes a meandering response that seems to attempt to refute the holding of Ford versus Wainwright, but then just restates it. The state does not try to provide a clear way of deciding when evidence of mental illness should be aggravating and when it should be mitigating. I can't stand the fact that they're even bringing that argument up right now. I really just can't, because if they full-heartedly believe that he's innocent the way that they act like they do, they wouldn't need to be sitting here trying to bring this sort of argument in right now. They're tiptoeing it. They're dipping their toes in, okay? This is how it feels. Simply telling a jury to find it aggravating if you think someone who has committed first-degree murder will kill again based on something beyond the fact that they are able to do it in the first place is not providing the kind of narrowing required by Furman. Mr. Kohberger provides this court with a solution to this issue. Mr. Kohberger argues that future dangerousness cannot be a statutory aggravator, but I'm disagreeing with you, Mr. Kohberger. Aggravators are intended for deciding which first-degree murderers merit the death penalty. Future dangerousness does not do that, but it does, because if you have been able to be deemed an actual danger to society, meaning that you cannot be free walking around, working a job, walking around grocery stores, driving in traffic with normal citizens because you're freaking insane and you're dangerous and you're careless and you don't care about human life, yeah, it does matter. It totally matters. As Mr. Kohberger notes, a jury can consider possible dangerousness, but only after Mr. Kohberger has been selected for the possibility of death. I agree. And that happens if he's found innocent or guilty, because if he's found guilty, they are probably going to give him death. I don't see how they possibly could get away with doing that with what we know now. It is so freaking empty. It's worse than a bag of potato chips, okay? There's nothing there. Everything that they have told us that they had has slowly been chipped away in every court hearing. And I think back to everything going on now with Delphi. Everything from the video that got released for who they thought the suspect actually was has been a bold-faced freaking lie. And it's been going on for 7 years. And if we didn't have people like Bob Motta and his wife, like Andrea Burkhart, and there's a lawyer, Lee, and a few other people, if we didn't have people like that actually fighting in line, staying up all night, just camping out on the courthouse steps, not eating lunch because as soon as they get released for the lunch break, they get right back in line to guarantee their seat back in. If we didn't have people like that in there right now, we would have no freaking clue how much we've been being lied to. And it's not just about Richard Allen, being innocent or guilty. It is about getting justice for Abby and Libby and their families, because this is insane. This is wildly insane. I would really love to know at this point what the families feel about the evidence now that they're seeing everything, and then comparing it to what they've been told by law enforcement when it comes to Richard Allen. I still have a bunch of this stuff's week to catch up on. I've been getting bits and pieces. I just went completely off track, but not really, because look at everything that the media has been saying so far about Bryan Kohberger. And like I said, every single thing, pretty freaking much, 99.99999% of everything that we've been told has been debunked in court by the people who told it to us. Cannot wait for trial. Cannot wait for trial. The state's response is that this court should not worry. After all, judges consider future dangerousness all the time. That is true. It is a typical consideration at sentencing. But the aggravators are not just factors for sentencing. They are intended to narrow those eligible for the death penalty based on the crime they have committed. And that is not something this aggravator does not do. Meaning it's not fair that you're trying to judge what somebody might do in the future for the punishment of the crime that they are being punished for at the moment, which I understand that argument. So I get it. But at the same time, I'm still on the side of, if you're capable of doing something like this, you don't deserve to be breathing and definitely not out walking amongst us. And that's just the facts, Jack. Okay, on to the next one. This is going to be the defense's response to the state's response to the defense's objection to remove the heinous, atrocious, and cruel aggravator from the case. I, at first, was really disagreeing with this, and honestly, just because of the way that I feel about the case, I'm still hella disagreeing with this, okay? There's nothing that you can tell me that's going to make me feel like this case is anything less than what it is. Heinous, atrocious, and cruel. Plain and simple. But when you read over the definitions of law, whenever you hear the arguments, which is why I'm really glad I really did it the way that I did it, because I have the defense's original argument, and then we are instantly hearing what the state had to say, and it sort of locked it in a hell of a lot more, for me anyway. I Google a lot of stuff, guys. I don't claim to know everything. But now that we've gone over the way that they have to do it because of the case law, it sounds as if the aggravator and the definitions for anything considered HAC is something that is more towards like a sadist, someone who is doing it for pleasure from somebody else's pain, somebody who enjoys making somebody suffer, somebody who wants to make somebody suffer for a long time through lots of torture, things like that. And what we've been hearing for the longest time is that this was something that happened fast. So if that part of this storyline is true, then I agree with the defense that the HAC aggravator should be removed, because if it happened in that 7-8 minute window, like they're trying to claim it did, then why are we trying to act like it's something that it's not? To keep the HAC aggravator means that there would have been time for somebody to sit there and enjoy somebody's pain and suffering, for somebody to be tortured, for several things to have happened, in my opinion, with the way that they're describing it. Now, when I also think of HAC, the way that they're describing it, the way the definitions are, it brings me back to the 4chan post in the very beginning of this case, before we ever had an arrest, before the cops even knew who Bryan Kohberger was. There was this 4chan post that came out that was disgusting. It was horrendous. It was atrocious. And it was definitely one of the most cruel things that I have ever put into my brain, at least at that point in time. It's been like 2 years. There's been a lot more since then. I'm not going to go into the details, but a lot of you here know exactly what I'm talking about. So whenever it comes to this aggravator and the way that we're being told it is in definition, I think about that. I think about that situation. I don't think about the storyline that they're trying to tell us. 7-8 minutes, manual weapon, middle of the night, dark, lights are all off. You don't know this house. You've never been in this house before. You have no idea whose door is whose, or do you? I don't know. Who knows? 7-8 minutes. You don't leave a blood trail outside of the house. No one hears anything. Come on. It doesn't make sense. He's not freaking John Wick, okay? Just no. So that's why I'm questioning. Why do they want to keep it in if their story is so quick? The defense wanting it removed, if that's not the case, makes a lot of sense. But like I also mentioned, none of them are using anything when it comes to the crime itself in their arguments. So again, I don't see how they can even have these arguments and how the judge can even make judgments on these arguments without knowing case fact from the murders themselves. And I really need that question answered about if those things are available for the judge whenever he makes these decisions on whether to approve or deny these. I really would like to know. Okay. This states, reply to state's objection to defendant's motion to strike HAC aggravator. Comes now Bryan C. Kohberger, by and through his attorneys of record, and submits the following, should say following, but it says the following reply to the state's objection to his motion to strike the HAC aggravator from the notice of intent to seek death penalty. The state argues that the HAC in Idaho is constitutionally based. That's the second. Come on, Anne. Who wrote this? Jay. Come on, Jay. For real? That's number 2. Who's doing your proofreading? Because, I can take on a third job. Fourth job? One of them. The state argues that the HAC in Idaho is constitutionally based on the judicial gloss from Osborne. The state argues that Verska versus St. Alphonsus Regional Medical Center from 2011 does not change the Idaho Supreme Court's ability to change the law. Mr. Kohberger does not know exactly what the state's authority is for this conclusion, and the state appears to be comparing the idea of rewriting ambiguous laws with limiting constructions and finding a difference. State's brief at 4. What the difference is not defined. The state does not argue that the HAC is ambiguous. If the state agrees that it is ambiguous, the state provides no case that permits the Idaho Supreme Court to rewrite the statute to clarify it. The larger issue that the United States Supreme Court suddenly created the power to rewrite statutory language to preserve the death penalty goes essentially unanalyzed in the state's objection. Again, even if this court cannot overrule the Idaho Supreme Court, it can acknowledge where its holding violates the principles of law upon which our system was founded. The state then takes up the differences between the ICJI and Osborne and notes that they match. They do. All but like one little fragment. And all it does is take it away from being a human to it being a very generalized crime. But other than that, it's the same. Counsel for Mr. Kohberger admits that in May of this year, the ICJI was amended to reflect the language of the opinion. However, that merely reinforces his original argument that this aggravator was not written by the legislature, but rather by the Idaho Supreme Court. Mr. Kohberger cannot be put to death on the grounds of an aggravator that was not adopted by the legislature. Oh my God. Okay. So basically he's claiming that, while the state's correct in claiming that these two are all the same, it didn't actually take effect until May. So therefore it didn't exist whenever Bryan was charged, is how I'm understanding it. Again, I could be wrong, but that's how I'm interpreting this. And remember, I showed you guys in 2 videos now, they've had a link for it. And I mentioned how it's funny to me that they ended up arguing the grand jury instructions all the way up to the Supreme Court. But then all of a sudden we get death penalty jury instruction update in May of this year. So I wonder if whatever was in the argument for the grand jury instructions was something that could have also been used for the jury instructions for the death penalty. And they were trying to hurry up and clean up the problem after seeing what Ann Taylor was going to complain about for the grand jury instructions before the situation with Bryan actually went to trial. They're sneaky. That wouldn't surprise me. Now, like I mentioned, I'm in the middle of editing the multiple victims one. So I'm going to read this newest document at the end of that video. I'm going to end up doing the motion to strike utter disregard aggravator. All 3 will be in one video after that. So at this point, we only have, I think, 2 that we need to go over that are not aggravators. Because honestly, if you guys remember, there was one for getting rid of the felony murder aggravator, and they didn't, the state didn't object to it. They sort of just responded to it, claiming that it should be null and void because there was something that they were already doing, which was taking away one of their aggravators for their death penalty. They're now seeking it under 4 instead of 5 factors. And because they made that change, they're basically claiming that the felony murder aggravator striking motion from the defense was no longer necessary. So we don't really have one for that, but we did do one for their motions to trifurcate the proceedings. Okay, so let's see what the defense had had to claim back to their response because they don't want to cut it into thirds. The state wants to leave it as it is in 2 sections because there's only been like one other case ever where that's ever happened. And like, it's been talked about several times and it always ends up going back to no, it needs to be left alone as 2 bifurcated. So let's see what the defense is claiming their reasoning is at this point. To me, the way that the state was responding back to the defense's original motion, it was almost as if the defense was almost asking for the method in which, or the process and procedure in which these trials take place to be a little bit backwards. And it didn't make a lot of sense to me. It still doesn't make a lot of sense to me. So let's see if this sort of clears it up. Okay. Reply to state's objection to defendant's motion and memorandum in support of motion to trifurcate the proceedings and apply rules of evidence during the eligibility phase. Comes now Bryan C. Kohberger, by and through his attorneys of record, and submits the following reply to the state's objection to his motion and memorandum in support of motion to trifurcate the proceedings and to apply the rules of evidence during eligibility phase. That is such a long title for such a itty-bitty paper. Okay. The state objects to the idea of a trifurcated proceeding on the ground that it is not contemplated by statute, difficult in practice, and objectionable in post-conviction proceedings. As to the statutory scheme, nothing in the statute prevents trifurcation, which is true. Nothing prevents it. As it states in IRE 611, it is important for a court to decide how evidence should be presented to arrive at the truth. Mr. Kohberger argues that trifurcation would be helpful in that regard for the various reasons he has argued. I don't feel like the argument had anything to do with that. Not with the way that they were arguing it. As to how difficult it is to do, Mr. Kohberger's attorney, Mr. Logsden, was of counsel in Renfro and took part in the trifurcation in that case, which was not difficult. That's the one case Idaho has ever allowed that in. Of course, Logsden, and he's talking about himself in the third person. Maybe he has to. I don't know. Whatever post-conviction counsel may think about how it was handled in that case, it certainly was not awkward or difficult to do. And the fact that various other jurisdictions Mr. Kohberger has already listed in his motion affirms that. Mr. Kohberger would note that the state's example of what may cause confusion, the propensity aggravator, or what we just read a second ago, the last one, is actually a good example of why the statutory aggravator ought to be struck entirely. It simply is not the sort of aggravator that should exist in the eligibility phase. And that's what this whole thing is, like different phases of the trial. The real problem this court has to grapple with is the hodgepodge death penalty. I can't. Hodgepodge death sentencing scheme Idaho has due to its transition from a judge as sentencer to jury as sentencer state. It is not one thing to throw all of this information at a trained lawyer and expect to get a well-reasoned decision, and quite another to do it to 12 citizens with no formal training. Okay, well, citizens have common sense. They can hopefully put 2 and 2 together. Add to this that the case law itself on what aspects of the scheme should help the selection process as opposed to the sentencing process, and it can feel like too much to try and figure out how to provide jurors with a logical and understandable system. However, that is the job that must be done. To get there, Mr. Kohberger has only requested a trifurcated trial. He has also pointed out that each of the statutory aggravators in this case have crippling flaws. Assuming this court determines that any of them survive scrutiny, a trifurcated proceeding is the only reasonable way to proceed. So if everything that we said gets proven correct as it should be, then trifurcating this damn thing is the only way to make it work. That's how I am hearing that in my head. Okay, you guys, so I lied. That's actually the last one. I'm not going to go over the other document I wanted to go over because it's 16 pages long and it needs a video for itself, because the title of it is the amended motion to strike state's notice of intent to seek death on grounds of means of execution. And it's going to be a long one. I'm going to put that by itself, but this video will be the first one to come out. It will not be tonight, Friday the 25th. It is just too late. It is already 8 o'clock at night. By the time I get everything edited, everything downloaded, everything uploaded, it'll be like midnight. So I'm going to do all of my recording and editing now and get this one up first thing on Saturday morning. So let me know what you guys think down in the comments about these arguments so far. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you were not subscribed already. And don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.